Basing employment decisions on factors other than worker qualifications is generally illegal in the United States. The costs of litigation, penalties, and harm to an organization's reputation can be substantial when violations occur. Civil rights activists in the United States used nonviolent means to protest unequal treatment during the turbulent 1950s. This led to the passage of important non-discrimination laws and guaranteed an equal employment opportunity for all individuals. Equal employment opportunity means that employment decisions must be made on the basis of job requirements and worker qualifications. With the enactment of the Civil Rights Act of 1964, specifically Title VII, workers of all backgrounds were provided a more level playing field in terms of employment opportunities. Since then, a number of additional laws and executive orders have been implemented to prohibit illegal discrimination in the workplace. While the Civil Rights Act stands as the foundation of equal employment laws, it's by no means the only regulation affecting employer-employee relationships. There are other laws that regulate how issues such as an individual's age, disability, and pregnancy status are addressed at work. Unlawful discrimination occurs when those decisions are made based on protected characteristics, which are individual attributes such as race, age, sex, disability, or religion that are protected under EEO laws and regulations. These categories are considered protected characteristics under various employment laws and regulations. All workers are provided equal protection. In other words, the laws do not favor some groups over others. These factors are not work-related and should not be considered. Federal protected classes include race, color, religion, national origin, sex, age, physical or mental disability, veteran status, genetic information, and citizenship. Equal employment opportunity, or EEO, is employment that's not affected by illegal discrimination. It's a broad-reaching concept that essentially requires employers to make status-blind employment decisions. Status-blind decisions are made without regards to individuals' personal characteristics, like age, sex, or race. Most employers are required to comply with EEO laws. Alternatively, affirmative action involves taking proactive measures to increase the number of women and minorities in the workplace in an effort to make up for past patterns of discrimination. This approach allows employers to consider various personal characteristics when making employment decisions. The employment relationship is governed by a wide variety of regulations, and all three branches of government have played a role in shaping these laws. Let's take a look. Federal statutes enacted by Congress form the backbone of the regulatory environment, but state and city governments also enact laws governing activity within their regions. Various state laws add a degree of complexity to the interpretation and prevention of workplace discrimination. Companies should be aware of legislation that may cover employees based on where the company conducts its business. The courts interpret these laws and rule on cases, providing guidance about how companies should comply with EEO regulations. Case law helps employers understand how laws are applied and what they must do to comply. Executive orders are issued by the President of the United States to help government departments, agencies, and contractors manage their operations. Government agencies responsible for enforcing laws issue guidelines and rules to provide details on how the law should be implemented. Employers then use these guidelines to meet their obligations in complying with the laws. The two main enforcement bodies for EEO are the Equal Employment Opportunity Commission, EEOC, and the U.S. Department of Labor, in particular the Office of Federal Contract Compliance Programs, or OFCCP. The EEOC enforces employment laws for employers in both private and public workplaces. For example, the EEOC recently outlined a strategic enforcement plan encouraging companies to develop fair criminal background screening practices, establish equitable pay for both men and women, and take steps to reduce workplace harassment. The OFCCP enforces employment requirements set out by executive orders for federal contractors and subcontractors. Many states have enforcement agencies to ensure compliance with state employment laws. Compliance can be complex for companies that operate in multiple states. Discrimination remains a concern as the U.S. workforce becomes more diverse. HR professionals need to be sensitive to trends in the workplace that can precipitate negative legal actions. The first type, disparate treatment, occurs when individuals with particular characteristics that are not job-related are treated differently from others. This type of discrimination is typically overt and intentional, and it often follows a pattern or practice. For example, if female applicants are asked interview questions regarding childcare plans while male applicants are not, then disparate treatment may be occurring. Disparate impact is the second type of illegal discrimination. It occurs when an employment practice that does not appear to be discriminatory adversely affects individuals with a particular characteristic so that they are substantially underrepresented as a result of employment decisions that work to their disadvantage. This type of discrimination is often unintentional because identical criteria are used, but the results can differ for certain groups. For example, using a test for firefighters that requires candidates to carry a 100-pound sack down a ladder could result in more women being eliminated from selection. The same job-related test is used for all candidates with markedly different results on the basis of sex. Unlawful discrimination can occur in any number of employment-related decisions, including recommendations for advancement opportunities, selection for training seminars, allocation of rewards, and layoffs and terminations. Employers should analyze job requirements, keep good records, and review personnel actions to make sure that employment decisions are lawful and prevent claims of disparate treatment and disparate impact. Managers can also be taught to recognize situations that can lead to discrimination. The four key concepts to help clarify EEO ideas and lead to fair treatment and non-discriminatory employment decisions include business necessity, BFOQ, burden of proof, and non-retaliatory practices. A business necessity is a practice necessary for safe and efficient organizational operations. Business necessity has been the subject of numerous court cases. As an example, educational requirements are often decided on the basis of business necessity. Employers may discriminate on the basis of sex, religion, or national origin if the characteristic can be justified as a bona fide occupational qualification necessary to the normal operation of the particular business or enterprise. Thus, a bona fide occupational qualification, BFOQ, provides a legitimate reason an employer can use to exclude persons on otherwise illegal basis of consideration. The application of a BFOQ is very narrowly determined, and an employer seeking to justify hiring on this basis is advised to obtain prior authorization from the EEOC. When a legal issue regarding unlawful discrimination is raised, the burden of proof must be satisfied to file suit against an employer and establish that illegal discrimination has occurred. The plaintiff charging discrimination must establish a prima facie case of discrimination, meaning that sufficient evidence must be provided to the court to support the case and allow the plaintiff to continue with the claim. The plaintiff must then show either that the employer's motivation or rationale was a pretext for discrimination, or there's an alternative employment approach that would not result in discrimination. The plaintiff maintains the final burden of proof that unlawful discrimination underlies an employment decision. Employers are prohibited from retaliating against individuals who file discrimination charges. Retaliation occurs when employers take punitive actions against individuals who exercise their legal rights. To prevent charges of retaliation, the following actions are recommended for employers. Create and disseminate an anti-retaliation policy. Train supervisors on what retaliation is and what actions are not appropriate. Review all performance evaluation and discipline records to ensure consistency and accuracy. Conduct a thorough internal investigation of any claims and document the results. And finally, take appropriate action when any retaliation occurs. Even though HR professionals and operating managers may follow these actions, EEOC investigations sometimes occur when allegations of retaliation and other forms of unlawful discrimination are advanced. Human resource professionals must develop a plan that enables a response to allegations and protects the interest of both the organization and its employees. Anti-discrimination law refers to laws on the rights of people to be treated equally. Although the very first Civil Rights Act was passed in 1866, it was not until the passage of the Civil Rights Act of 1964 that the keystone of anti-discrimination employment legislation was put into place. Title VII, the employment section of the Civil Rights Act of 1964, details the legal protections provided to applicants and employees and defines prohibited employment practices. Title VII is the foundation on which all other workplace non-discrimination legislation is built. Title VII of the Civil Rights Act states that it's illegal for organizations to discriminate in any way based on a person's sex, race, national origin, color, or religion. Coverage includes hiring decisions, terminations, promotions, demotions, compensation, working conditions, and many other personnel actions. Title VII, as amended by the Equal Employment Opportunity Act of 1972, covers most employers in the United States. Any organization meeting one of the following criteria must comply with the rules and regulations that specific government agencies have established to enforce the Act. All private employers of 15 or more employees, all educational institutions, public and private, state and local governments, public and private employment agencies, labor unions with 15 or more members, and joint labor management committees for apprenticeships and training. Title VII has been the basis for several extensions of EEO law. For example, in 1980, the EEOC interpreted the law to include sexual harassment. In response to several U.S. Supreme Court decisions during the 1980s, Congress amended the Civil Rights Act of 1994 to strengthen legal protection for employees, provide the basis for jury trials, and allow for damages payable to successful plaintiffs in employment discrimination cases. Several important executive orders have been issued by the U.S. President that affect the employment practices of federal contractors and subcontractors. The OFCCP in the U.S. Department of Labor is responsible for overseeing federal contract operators and ensuring that unlawful discrimination does not occur. Executive Orders 11246, 11375, and 11478 require federal contractors to take affirmative action to compensate for historical discrimination against women, minorities, and individuals with disabilities. Federal contractors are required to develop and maintain a written affirmative action program, AAP, that outlines proactive steps the organization will take to attract and hire members of underrepresented groups. This data-driven program includes analysis of the composition of the company's current workforce with a comparison to the availability of workers in the labor market. The overall objective of the AAP is to have the company's workforce demographics reflect as closely as possible the demographics in the labor market for the workers who are recruited. The contents of an affirmative action program and the policies flowing from it must be available for review by managers and supervisors within the organization. In addition to extensive workforce analysis, the AAP includes goals, timetables, and documentation of good faith efforts to reduce and prevent employment discrimination against historically disadvantaged groups. Organizations implement outreach programs, targeted recruiting, and training programs to recruit and advance women, minorities, and people with disabilities. The original purpose of the Civil Rights Act of 1964 was to address race discrimination in the United States. This concern continues to be important today. To take appropriate actions, employers should be aware of potential HR issues that are based on race, national origin, and citizenship. Sexism or gender discrimination is prejudice or discrimination based on a person's sex or gender. The Pregnancy Discrimination Act of 1978 amended Title VII to require that employers treat maternity leave as the same as other personal or medical leaves. Courts have generally ruled that PDA requires employers to treat pregnant employees the same as those who are not pregnant. Closely related to the PDA is the Family Medical Leave Act, or FMLA, of 1993. The FMLA requires that qualified individuals are given up to 12 weeks of unpaid family leave, and also requires that those taking family leave be allowed to return to their jobs. The FMLA applies to both men and women. The ADA-AA has expanded the definition of disability to include less permanent and serious physical and mental issues, which can be interpreted to cover pregnancies. The Equal Pay Act of 1963 requires employers to pay similar wage rates for similar work without regard for gender. A common core of tasks must be similar to justify similar wages. Tasks performed only intermittently and infrequently do not make jobs different enough to justify different wages. Differences in pay between men and women in the same jobs are permitted because of differences in seniority, in performance, in quantity or quality of production, and factors other than sex, such as skill, effort, or working conditions. In response to a procedural issue in pursuit of fair pay claims, Congress enacted the LILLY-LEDBETTER Fair Pay Act in 2009. This law eliminates the statute of limitation for employees who file pay discrimination claims under the Equal Pay Act. Each paycheck is essentially considered a new act of discrimination. Lawmakers recognize that because pay information is often secret, it might take months or even years for an employee to discover the inequity. The successful plaintiff can recover up to 2 years of back pay. Pay equity involves the idea that pay for jobs requiring comparable levels of knowledge, skill, and ability should be similar, even if actual duties differ significantly. Employers can take some steps to reduce pay inequities, including the following. For the most accurate overall picture, include all benefits and other items that are part of pay to calculate total compensation. Make sure that people know how the organization's pay practices work. Base pay on the values of jobs and performance. Benchmark against local and national markets so that pay structures are competitive. And conduct frequent audits to ensure that pay is fair internally and that there are no gender-based inequities. While there's no federal law prohibiting discrimination on the basis of sexual orientation, 18 states and the District of Columbia have passed laws to protect applicants and employees from such discrimination. In addition, various court decisions prohibit same-sex sexual harassment in the workplace. Sex discrimination based on stereotypical gender attributes about appropriate and inappropriate mannerisms, appearance, and conduct is also inappropriate. An issue that some employers have faced is that of individuals who have had or are undergoing gender transition surgery and therapy. Federal court cases and the EEOC have ruled that sex discrimination under Title VII applies to a person's gender at birth. Thus, it does not apply to the new gender of those who've had sex transformation operations. However, managers and employees should be tolerant of such situations and show respect for individuals undergoing these procedures by making the right accommodations when needed. The influx of women into the workforce has had major social, economic, and organizational consequences. In particular, the growing number of women has led to more sex and discrimination issues related to jobs and careers. Sexual harassment is unwelcome verbal, visual, or physical conduct of a sexual nature that is severe and affects working conditions or creates a hostile work environment. Sexual harassment can occur between a boss and subordinate, among coworkers, and when non-employees have business contact with employees. Sexual harassers can be either managers or employees. In other words, working in a position of authority is not a prerequisite for such misconduct. Sexual harassment is therefore not a gender-specific issue. Both men and women can be targeted by perpetrators of either gender. Unfortunately, many claims of harassment go unreported because victims are uncomfortable, embarrassed, or concerned about retaliation in the workplace. Two basic types of sexual harassment have been defined by EEO regulations and a number of court cases. Quid pro quo sexual harassment links employment outcomes to the granting of sexual favors. In quid pro quo harassment, an employee may be promised a promotion, a special raise, or a desirable work assignment, but only if the employee grants some sexual favor to the supervisor. Since supervisors are agents of the company always bears liability for quid pro quo sexual harassment. Hostile work environment sexual harassment occurs when an individual's work performance or psychological well-being is unreasonably affected by intimidating or otherwise offensive working conditions. Hostile work environment harassment may include actions such as complimenting on appearance or attire, telling jokes, or suggestive sexual nature comments. It can also include allowing revealing photos and posters to be displayed or making continual requests to get together after work. These actions can lead to the creation of a hostile work environment. If the employer has taken appropriate steps to prevent sexual harassment, it may be possible to offer an affirmative defense and prevail in a lawsuit. A proactive, preventative approach is the most effective way to reduce sexual harassment in the workplace. If the workplace culture fosters harassment, and if policies and practices do not inhibit harassment, an employer is wise to reevaluate the workplace and solve the problem before lawsuits occur. This requires managers and HR professionals to take certain steps. Companies may avoid liability if they take reasonable care to prohibit sexual harassment. This process is tied into what's called an affirmative defense. Important elements of the affirmative defense include the following: establish a sexual harassment policy, communicate the policy regularly, train employees and managers on avoiding sexual harassment, and investigate and take action when complaints are voiced. Companies also need to make sure that sexual harassment policies establish clear standards for appropriate conduct. Employees should be also required to acknowledge in writing that they understand these policies. Effective training to prevent sexual harassment ideally includes information about how to report sexual harassment incidents when they occur. Disability discrimination is when a person with a disability is treated less favorably than a person without the disability in same or similar circumstances. The Rehabilitation Act was passed in 1973 and represents the earliest law regarding individuals with disabilities. The law applies only to federal contractors and requires them to take affirmative action to employ workers with disabilities based on steps outlined in the contractor's AAP. 2 decades after the passage of the first law prohibiting discrimination against individuals with disabilities, the Americans with Disabilities Act was enacted in 1990. The act applies to private employers, employment agencies, and labor unions with 15 or more employees. It is enforced by the EEOC. In 2009, Congress passed amendments to the Americans with Disabilities Act, overruling several key cases and regulations and reflecting the original intent of the ADA. The effect was to significantly broaden the definition of individuals with disabilities and include anyone with a physical or mental impairment that substantially limits a major life function without regard for helpful effects of medication, prosthetics, hearing aids, and so on. This establishes a very low threshold for establishing whether an individual isn't disabled under the law. A 3-pronged test is used to determine whether an individual meets the definition of disabled. A person must meet one of the following 3 conditions as stated in the ADA and modified by the Americans with Disabilities Amendment Act. A person with a disability is someone who, 1, has a mental or physical challenge that greatly reduces the ability to perform important life functions, 2, possesses a record of such a challenge, or 3, is thought to have such a challenge. Discrimination is prohibited against individuals with disabilities who can perform essential job functions, that is, the fundamental job duties of the employment positions that those individuals hold or desire. These functions do not include marginal functions of the position. Qualified person with a disability, an employer must make a reasonable accommodation. This involves modifying a job or work environment to give that individual an equal employment opportunity to perform. EEOC guidelines encourage employers and individuals to work together to determine the appropriate reasonable accommodation, rather than simply employers alone making these judgments. Reasonable accommodation is limited to actions that do not place an undue hardship on the employer. An undue hardship occurs when making an accommodation for individuals with disability imposes a significant difficulty or expense on the employer. The ADA offers only general guidelines for determining when an accommodation becomes unreasonable and will create undue hardship for an employer. The ADA restricts employers' attempts to obtain and retain medical information related to applicants and employees. Restrictions include prohibiting employers from rejecting individuals because of a disability from asking job applicants any question about a current or past medical history until the conditional offer of employment is made. An additional ADA requirement is that all medical information be maintained in files separated from general personnel files. They must be stored in a secure location, and access should only be granted on a need-to-know basis. Prior to the Americans with Disabilities Act Amendment Act, employers won 90% of challenges regarding whether an individual actually had a disability. Now that argument is essentially moot. Companies no longer aggressively work to disqualify individuals from the status of disability. Age discrimination in the workplace is the practice of letting a person's age unfairly become a factor when deciding who receives a job, promotion, or other job benefits. The Age Discrimination in Employment Act, or ADEA, of 1967, amended in 1978 and 1986, prohibits discrimination in terms, conditions, or privileges of employment against all individuals age 40 or older employed by organizations having 20 or more workers. As with most equal employment issues, what constitutes age discrimination continues to be defined by the courts and the EEOC. Individuals who believe they've been discriminated against based on age usually must show that they are a member of a protected group based on age, were performing well in the job, were terminated in part because of age. However, based on the U.S. Supreme Court decision in Gross v. FBL Financial Services in 2009, individuals must show that age was the but-for trigger of a particular personnel decision. This means that age must be the key factor that causes a particular outcome. The Older Workers Benefit Protection Act is an amendment to the ADEA and protects employees who sign liability waivers for age discrimination in exchange for severance packages during reductions in force. This act ensures that older workers are not pressured into waiving their rights under the ADEA. To ensure compliance when developing procedures for laying off older workers, organizations must ensure legal oversight and strict protocol. One issue that's led to age discrimination charges is saying that older workers are overqualified for certain jobs or promotions. A recent survey found that many older workers find the job search process challenging, and about 1/3 are called overqualified. In a number of cases, courts have ruled that the term overqualified may have been used as a code word for workers being too old, thus causing them not to be considered for employment. Selection and promotion practices must be age neutral. In some cases involving older employees, comments made by employers such as new blood were considered to determine if age discrimination existed. Managers and employees need to be careful about making comments that could be viewed as biased or discriminatory. A strategy employers use to retain the talents of older workers for a period of time is phased retirement, an approach that enables employees to gradually reduce their workloads and pay levels. This option is growing in use as a way to provide greater personal flexibility to older workers with significant knowledge and experience. Organizations also retain them for their valuable capabilities. Some firms rehire their retirees as part-time workers, independent contractors, or consultants, strategies intended to help the company retain its institutional knowledge and history. Companies should provide training to managers and employees to educate them about age-related biases and stereotypes. It's also important to encourage them not to make comments that could be seen as biased against older workers. Title VII of the Civil Rights Act prohibits discrimination on the basis of religion. Religious discrimination can take many forms, from hostile remarks to refusal to promote individuals because they have different beliefs. Employees should avoid making comments that could be viewed as offensive to someone's religious belief. Employment decisions should not be influenced by workers' religious beliefs. A related issue concerns religious expression. Employees have sued employers for prohibiting them from expressing their religious beliefs at work. In other situations, employers have taken action because workers complain that their colleagues are aggressively pushing their religious views at work, thus creating a hostile work environment. Organizations should also be cautious about promoting certain religious practices and faiths. Executives and owners of some organizations have strong religious beliefs that are carried over into their companies. Some even display religious symbols, sponsor religious study and prayer sessions, and support other religious efforts. but such actions can alienate those with different beliefs and create a negative work environment. To achieve consistency, employees of all faiths should be given the opportunity to display religious symbols in similar and often specified ways. Employers must make reasonable accommodation efforts regarding an employee's religious beliefs unless they create an undue hardship for the employer. Problems can arise because of conflicts between employer policies and employee religious practices, such as dress and other aspects of appearance. Managing religious diversity can be a significant challenge for organizations. The EEOC recommends that employers consider the following reasonable accommodations for employees' religious beliefs and practices: scheduling changes, voluntarily substituting shifts and swapping shifts, changing an employee's job tasks or providing a lateral transfer, making an exception to dress and grooming rules, making accommodations to paying union dues or agency fees, making accommodations related to necessary prayer, proselytizing, and other forms of religious expression. Generally, employers are encouraged to make exceptions to their dress code policies unless public image is so critical that it represents a business necessity. Deferring to customer preferences and making these determinations is risky and may lead to charges of unlawful discrimination. Sometimes religion can be used directly to make employment decisions. Faith-based schools and universities can use religion as a BFOQ or a bona fide occupational qualification for employment practices on a limited scale. For example, a university affiliated with a particular religion can lawfully ask questions about job applicants' religious beliefs and evaluate responses when they're making hiring decisions when the job involves promoting a particular faith. Recent evidence suggests that religion may not be an overwhelming challenge for organizations. In fact, it may be used to create a competitive advantage. A workplace opinion survey found that 44% of workers discuss religion and politics with their colleagues, but only 9% think that the religion is the main cause of workplace conflict. Further, 17% claimed that the main cause of conflict involves disagreement over politics, and 52% pointed to work issues. In addition to Title VII protections, a number of federal laws have been enacted to address these forms of discrimination. Many of these laws were passed in response to improper company decisions that resulted in unfair treatment of applicants and employees. The Immigration Reform and Control Act, or IRCA, enacted in 1986, requires that employers verify the employment eligibility status of all employees, while not discriminating because of national origin or ethnic background. Employers may not knowingly hire unauthorized workers for employment in the United States. Within the first 3 days of employment, each employee must complete an employment eligibility verification form, commonly called the I-9, and provide documents proving that he or she is legally authorized to work in the United States. The employer is required to inspect the documents and maintain records for all new hires. As the diversity of the workforce increases, more employees have language skills in addition to English. Interestingly, some employers have attempted to restrict the use of foreign languages at work, while other employers have recognized that bilingual employees have valuable skills. There's been much debate on both sides of this issue. EEOC guidelines have not been entirely clear about how companies should address these language issues in the workplace. The employment rights of military veterans and reservists have been addressed in several laws. The two most important are the Vietnam-era Veterans Readjustment Assistance Act of 1974 and the Uniformed Services Employment and Reemployment Rights Act, or URISA, of 1994. Under the former, federal contractors are supposed to provide employment opportunities for veterans based on percentage benchmarks that are not related to quotas. Under the latter, employees are required to notify their employers of military service obligations. Employers must then give employees serving in the military leaves of absence protections under URISA. Several EEOC cases have been filed concerning the physical appearance of employees. Court decisions consistently have allowed employers to set dress codes and appearance standards as long as they are applied uniformly. Also, employers should be cautious when enforcing dress standards for female employees whose religious practices prescribe appropriate and inappropriate dress and appearance standards. Some individuals have brought cases of employment discrimination based on height or weight. Employers must link any weight or height requirements to specific job functions. Complying with this complex array of regulations requires diligence and careful record keeping. A primary goal of diversity training is to minimize discrimination and harassment lawsuits. Other goals focus on improving acceptance and understanding of people with different backgrounds, experiences, capabilities, and lifestyles. Employees are encouraged to recognize, evaluate, and appreciate differences. Diversity training programs often have three components. Legal awareness is the first and most common component. Cultural awareness training then helps all participants see and accept the differences in people with widely varying cultural backgrounds. Sensitivity training aims to sensitize people to the differences among them and how their words and behaviors are seen by others. The results of diversity training are viewed as mixed by both organizations and participants. Studies on the effectiveness of diversity training raise some concern that the programs may be interesting or entertaining, but not produce longer-term changes in people's attitudes and behaviors towards others with characteristics different from their own. Some argue that traditional diversity training more often than not has failed because it has not reduced discrimination and harassment complaints. Rather than reducing conflict, in a number of situations diversity training has increased hostility and conflict. Effects have not changed behaviors so that employees can work well together in a diverse workplace. Negative consequences of diversity training may manifest themselves broadly in a backlash against all diversity efforts. Women and members of racial minorities sometimes see diversity programs as inadequate and nothing but lip service. Thus, by establishing diversity programs, employers may raise expectations but fail to meet them. Some individuals who are in the majority, primarily white males, may also interpret the emphasis on diversity as assigning the blame for social problems. Finally, diversity programs might be perceived as benefiting only women and racial minorities and taking away opportunities from these majority members. Focusing on behavior seems to hold the most promise for making diversity training most effective. For instance, cultural diversity training that teaches sales representatives and managers how to positively communicate with people from diverse backgrounds should produce positive results. At the end of the day, dealing with diversity in the workplace is not about what people can and cannot say. It's about being respectful to others.